Hey everybody, welcome to the webinar on the international cannabis trade. We're excited to be here for you. We're going to go for about an hour. My name is Vince Sliwoski. I'm going to be moderating and covering just a few sections. I'm in the Portland office of our law firm. I do a fair amount of international cannabis work with respect to public international law, but also with respect to private contracts and actors. And then I do a lot of domestic work here in the US, both in Oregon and nationwide. You'll see on the screen Natalie Bougenet. She's also in the Oregon office. Natalie's actually a native of Belgium, and she does a lot of work in the CBD and hemp space, including for import and export of hemp all around the world. We've got this handsome guy with the goatee, Griffen Thorne, in our Los Angeles office. Griffen does similar work to Natalie. He's another business lawyer. He's very talented on import, export, and international cannabis issues, CBD issues, and all sorts of related stuff, including in and around data privacy and a lot of stuff for cannabis companies that are working all over the world. And then we've got the eminent Adams Lee. Adams is a customs and international trade lawyer, mostly. He's an international trade lawyer. He's been at it for how long, Adams? 20 some years, maybe? He's probably muted, but Adams has done international trade in all kinds of industries for many, many years and has been instrumental in helping our practice group here at the law firm navigate the cannabis trade, and Adams is based out of our Seattle office. So the outline of the webinar was pretty well established, I think, in the announcement. One thing I want to say is we are going to take questions, and we've already got a slew of questions before the webinar, and I kind of see them coming into the feed. We'll take them as appropriate, and we'll try to address them. There'll inevitably be a lot of them that we don't address. It's always like that. And we'll probably issue a follow-up post after the webinar addressing some that we couldn't get to that were relevant. And we'll probably repost the webinars in its entirety too. So if you're furiously taking notes or can't remember something, you'll have the opportunity to view this again at some point down the line. So I'm going to start the first section just by giving a really broad overview on public international law and cannabis. I think that'll be a good place for us to start, and it's going to kind of give some context to everything else that everybody says as we go ahead. So there's one giant treaty that kind of underpins all of this stuff, and it's called the Single Convention on Narcotic Drugs of 1961. It's a United Nations treaty, and it's joined by pretty much every country in the world. I think 186 of the 193 member UN states are signatories to the treaty. The treaty is a lot like a contract. It's binding on the members. There are sort of limited grounds for invalidating or terminating a treaty. In the case of the Single Convention, if somebody didn't want to be a part of it anymore, they might withdraw from the treaty. Countries have done that in the past, and then they can rejoin with a certain reservation. But that's sort of the general international order, I suppose, with respect to all narcotics and cannabis. The UN treaty, the Single Convention 1961, has been updated a couple of times or supplemented. There was a 1971 Convention on psychotropic substances. That's not exactly related, but it was sort of bundled in with the 1961 treaty with respect to a further later treaty called the 1988 Convention against illicit traffic in narcotic drugs. And what that does is make countries enforce their actual domestic laws with respect to the Single Convention. So it's not simply enough to outlaw certain forms of cannabis per se. There are actually obligations under international law that countries have to take with respect to all sorts of related issues such as money laundering or drug trade offense penalties, and it requires countries to enforce domestic laws that may be on their books with respect to drug trade offenses, including cannabis. So before the Single Convention, international law didn't control cannabis. Cannabis is kind of late to the game. There were early conventions and treaties that control things like opium and coca and derivatives like morphine and heroin and cocaine. And what the Single Convention did is it consolidated all of those treaties. I think the most recent was something called the Paris Convention in 1931, and it added cannabis, and it added a bunch of synthetic opioids and certain drugs that had sort of come into being or into prevalence over the previous 3 decades. And it also created this system of schedules, which is kind of an easy way for treaty members to add new drugs to the Single Convention, or to take drugs out of the Single Convention, or to move drugs up and down in terms of the severity of their controls under the Single Convention. And in any event, all of those international agreements that existed prior to the single convention in 1961 were sort of consolidated into and superseded by that. So what does it do? Well, it essentially limits possession, use, trade, distribution, import and export, manufacture, production of cannabis and other narcotic drugs. And it limits those activities strictly to medical and scientific purposes. So that's a really important exception to note. Under, say, US domestic federal law, for instance, we don't have a medical or scientific purposes exemption with respect to the control of cannabis, right? It's just a Schedule I drug, and they don't differentiate anything between medical or other types of uses. But international law does do that, and that's a big deal. Another big deal is the way that cannabis is actually defined under the UN Single Convention. Cannabis is defined as the flowering or fruiting tops of the cannabis plant. Sometimes we refer to those as buds, from which resin hasn't been extracted. The definition generally excludes leaves of the cannabis plant. So, to the extent somebody wanted to import or export cannabis leaves that weren't accompanied by the flowering or fruiting tops, the more psychoactive parts of the plant, I suppose, that would be okay. Also really important to note that Article 28 of the Single Convention specifically excludes industrial hemp from the regulations. It says, this convention shall not apply to cultivation of the cannabis plant exclusively for industrial purposes, fiber and seed, or horticultural purposes. So over the many years since 1961, almost 60 years now, we've had countries producing, importing, and exporting hemp legally under international law. Those countries include everything from China to EU countries like France and Germany. And only recently has certain countries like the US kind of come into this group by taking hemp out of the definition of what we call marijuana under our domestic laws. We'd sort of lumped everything in together, but a lot of other countries took a more nuanced approach and sort of followed the Single Convention and said, okay, for industrial purposes, for horticultural purposes, we're going to treat hemp differently and we're going to have a market here. And that was fine. I mentioned that there are 4 schedules of controlled substances. There's 1, 2, 3, and 4. 4 is the most heavily controlled. It's kind of the opposite of how we have it under the US Federal Controlled Substances Act, where 1 is the most heavily controlled. Cannabis, unfortunately, under the Single Convention, is placed in a couple of schedules. It's in 1 and 4. It was placed in Schedule 4 back in 1961, largely at the US's insistence. The argument for placing cannabis in that category was that it was very widely abused. Now, the UN, by and through one of its organs, the World Health Organization, later determined that cannabis does and could have medical applications after all. And people are looking at changing that now, but the structure was already in place for these many years, and there hasn't been any formal international action since 1961 to correct what is essentially an anomaly or an inappropriate placement of cannabis on a couple of different schedules in the Single Convention. Cannabis is also placed into the text of the treaty itself, making it impossible to deregulate just by dropping it from one or more of the schedules. Same with opium and coca. A lot of the drugs are actually in the body of the treaty as well as the schedules. The treaty did other things too, besides just scheduling drugs. It created something called the Commission on Narcotic Drugs. It allowed the World Health Organization to add and remove and transfer drugs in conjunction with that body, and the World Health Organization is indeed exploring that with respect to cannabis right now. It also created something called the International Narcotics Control Board. The INCB is in charge of administering controls on drug production in international trade, and the INCB monitors the international trade of controlled substances and puts out reports every year that you can go dig around and read on the internet with respect to raw imperial tonnage of cannabis being shipped here and there, which is sort of interesting. It's important to note that the Single Convention is not what we call a self-executing treaty. And by that, I mean that countries are required to pass domestic laws to implement the treaty and to carry out its provisions. So I've already mentioned the Federal Controlled Substances Act in the US a couple of times. That happened in 1970, about 10 years later. And that was actually an international obligation of the United States to pass that law because of its signature on the single convention. People sometimes say, oh, the US passed the Controlled Substances Act because President Nixon was evil and he hated hippies and black people and all this. And that's probably true. He did hate those people and he did have a bad motive. But in a certain sense, the US was constrained, and just like every other country, with respect to what it could do with domestic legislation in and around controlled substances, and it had to pass those laws. And countries kind of bump up against the single convention. Similarly, when they moved to legalize cannabis, right? When Canada recently legalized cannabis federally, it violated its obligations of the Controlled Substances Act, or excuse me, under the single convention, and it hasn't yet withdrawn. So countries, by legalizing cannabis for other purposes than medical purposes, are in violation of their single convention obligations. There's no enforcement of public international law like that, so it's kind of a funny, it's almost like a political situation rather than like a police type action, but the treaty sort of is set up like that. What else can I tell you? That's probably all except for the WHO piece, which I think is really important. The United Nations has recently been looking a little bit more carefully about how it categorized cannabis under the single convention and if it did that correctly. And the consensus seems to be no. The World Health Organization has made certain findings. One of them is that CBD, which all of you guys have heard about, cannabidiol, the non-psychoactive cannabinoid found in marijuana and hemp. The WHO said CBD exhibits no effects indicative of any abuse or dependence potential, right? So CBD probably shouldn't be lumped in on Schedule 4 and Schedule 1. And the WHO made a report with recommendations to change the way that cannabis is treated under international law in the single convention. One of them is just to remove whole plant marijuana in cannabis rather than from Schedule 4. Another one is to place cannabis extracts and tinctures containing THC in Schedule 3. So still to control THC from cannabis, but not quite as heavily, or not penalize it quite as heavily. One is to remove THC from the 1972 protocol to the single convention. So essentially remove penalties or the requirement that countries penalize users and manufacturers of THC. And another is just to clarify that CBD preparations containing trace amounts of THC, and they put the number at 0.2%, are not under international control at all. So it would be a really radically different approach under international law to cannabis. There was supposed to be a vote yesterday, finally, on this. They kicked the can down the line to December. So we'll probably have a vote with the International Control Board and the WHO on rescheduling cannabis. And it may be rescheduled as soon as later this year, and that'll have a big sort of effect on everything else we're talking about today. But for now, it's strictly controlled. The WHO recommendations are only recommendations, and that's kind of where we're at. So that's the high level. I'm now going to turn it over to Griffen, who's going to talk a little bit more specifically about import and export of hemp flower.
Hey everyone, thanks Vince for that intro. I'm going to talk right now about the import of hemp plant material into the United States, and then Natalie will talk about export and import issues relative to hemp flower and other hemp-derived products. To start, Vince mentioned a little bit about, a lot about the Controlled Substances Act, which prohibits marijuana. And until very recently, the definition of marijuana in the Controlled Substances Act didn't distinguish between marijuana and hemp. So hemp was considered marijuana until December 20th of 2018, when President Trump signed what we call the 2018 Farm Bill. As of that time, hemp was removed from the Controlled Substances Act, and by definition from the Controlled Substances Import-Export Act, which is a federal law that regulates importation and exportation of controlled substances. So hemp is no longer affected by that law, which has kind of changed a lot of the game for importing products containing hemp. So earlier in 2019, a couple months after the 2018 Farm Bill was signed, there was a federal case that I think is kind of important and that has pretty straightforward reasoning out of the Central District of California. It was called Innovative Nutraceuticals versus the United States. Basically what had happened in that case was a company had tried to import hemp from like legally produced hemp in Spain to the United States on 3 or 4 separate occasions. Notably, all of this happened before the 2018 Farm Bill was signed. And at each time it happened, they were seized by Customs and Border Patrol. They were either destroyed without really any notice or hearing opportunities for the hemp company. And so they filed this lawsuit seeking both damages for the destruction improperly and alleging that there were due process violations by not giving them notice provisions. There were also allegations, or excuse me, claims to enjoin, i.e. to prohibit the government from enforcing these laws in the future, and to force them to affirmatively create processes to determine whether or not something was hemp or marijuana. This was just a motion to dismiss case, so if you're not a lawyer, what that really meant was that this decision I'm going to talk about now isn't sort of the binding end-all decision of the case. In fact, that the case is still ongoing, and a second motion to dismiss is filed pretty recently. But there's the ruling and the verdict in this case, or not the verdict, but the reasoning in the case, I think are helpful. So the court said basically that because the 2018 Farm Bill was signed and removed hemp from the Controlled Substances Act, there is no future harm that the plaintiff can suffer, and all of its claims with respect to future violations by the government were moot. So in other words, it couldn't get an injunction prohibiting the government from seizing hemp because it was no longer legally allowed to, and it couldn't force the government to adopt hearing procedures when determining whether or not something is hemp and marijuana. This is good and bad. It's bad that the court didn't force the government to adopt the hearing procedures, or at least allow those claims to proceed, because part of the reasoning in that case was an argument by the plaintiff, Innovative Nutraceuticals, that the government had violated its due process rights by not employing better procedures to determine whether or not something is hemp. At the time when the hemp was seized, there were different parts of the plant that might have been considered marijuana or not, and the allegation was that proper procedures hadn't been followed to make that determination. So going forward, we won't have any sort of procedure to make that call. It's still up to the government, the federal government that is, to determine whether or not something is or is not marijuana. And so there is going to be a little bit of risk that a product that's imported into the country could be seized and destroyed with not sufficient notice procedures, irrespective of whether or not it actually is hemp. But guidance from the USDA has offered some sort of help for hemp companies in bringing hemp seed and hemp plant material into the United States. So shortly after that decision in March of last year, the USDA issued some guidance on its website, pretty short guidance, in which it talks about how to import plants and seeds, either from Canada or from countries that are not Canada. And the process is relatively similar in each case. So importation of plants and seeds is regulated by the USDA's Animal and Plant Health Inspection Service, which we'll just call APHIS. There's guidance on importing seeds, which is generally requires that the seeds be accompanied by phytosanitary certificates from the country of origin's National Plant Protection Organization. And these certificates need to verify first that the seeds are coming from that country, and two, that there aren't pests associated with the plant that have been detected on the seeds. So it's really a public safety issue in determining that the seeds are coming from the country where they're said to have come from and are not marijuana. There's a special certificate that companies need to use when bringing in seeds from Canada, but that only applies for Canada. When it comes to bringing in plant material, the rules are basically the same, which require those certificates, except there's a special APHIS permit that's required for countries besides Canada to import plant material. And then I should also note again that hemp and seeds and plants that come into the United States all get inspected by Customs and Border Patrol. And so again, if it's not accompanied by these things, it'll probably be rejected. But even if it is, there will be potential issues for seizure at the border if it looks or smells like marijuana. And I guess just a couple practical points. Hemp flower can often look and smell a lot like marijuana. And so we're dealing with agencies here that don't have tons of experience dealing with the nitty-gritty differences between hemp and marijuana. So it's very important that all steps are followed, because product could easily be seized at the border by agents who are overzealous or just don't understand what they're doing. Another issue is that product should really be accompanied by certificates of analysis or any sort of similar thing that's created in the country of origin. I know a lot of European countries have certificates of analysis for hemp, and so that will also bolster the claim that it is hemp and not marijuana. And finally, companies just should be prepared that if they're importing these things into the United States and they are pulled and searched and tested, there is a likelihood that they could, it's living material, it could degrade or something bad could happen to it, and they could lose the value of the product just by virtue of having to undergo this process. So there is some sort of natural risk associated with this that wouldn't necessarily be associated with the importation of a CBD product or something that is not going to rot or decay in a couple of weeks' time. So with that, that's really the summary, the universe of importing hemp seeds and plant material, and I'll turn it over to Natalie to talk about the next step.
Thanks, Griffen. So unlike for the importation of hemp and hemp seeds to the US, the USDA has yet to issue guidelines about the exportation of the crop and of these seeds, which of course makes the process pretty risky and challenging. According to our contact at the Oregon Department of Agriculture, agencies like the Foreign Agricultural Service and state regional trade groups are basically waiting to consult with foreign governments on whether or not the exportation of hemp and hemp seeds is allowed until the USDA basically comes up with some sort of strategy. Of course, we can argue that because hemp and its derivatives are now legal under the 2018 Farm Bill, that we should be able to export these products or the crop, but obviously there are many considerations that need to be taken, and obviously the fact that there isn't clear guidelines means that we're somewhat speculating as to what is required. So some of the things that I think are really important to keep in mind when deciding to engage in the exportation of hemp and hemp seeds is, first of all, to determine whether the state from which the crop or the seeds are being exported from allows for, first of all, the cultivation of hemp, and whether they have specific exportation requirements in terms of testing or labeling, potentially licensing requirements, because this would be treated as transportation. Also checking whether the state laws prohibit or limit these activities. For instance, in Oregon, it's strictly prohibited to export any kind of hemp commodity or products that contain more than 0.3% total THC. So those are the sorts of things to keep in mind. Of course, if a state now has no clear regulations on this issue, then I think you should at least have some sort of record of the chain of title, very similar to what Griffen was just explaining about, at a minimum, having copies of the grower licenses and certificate of analysis to at least be able to show that what you're trying to export was lawfully produced. So that's really from the US. Now you also need to determine whether the country to which the hemp and hemp seeds will be delivered authorizes the importation of the crop. If they do, then what are the country standards? Do they have certifications or regulations that may apply to the crop? Of course, these requirements vary from country to country, even within the EU. Most countries imposed additional regulations, again, testing, labeling, licensing requirements before the crop may enter their market. For instance, I just mentioned the EU. Hemp seeds that can be sold within the EU market generally cannot contain more than 0.2% THC, or at least the crop that will grow from those seeds cannot exceed that THC level. So those are important points given the fact that in the US we have a 0.3% total THC requirement. So that's a pretty significant factor. And of course, when you're exporting, there are just general issues to keep in mind, such as, confirming duties, taxes, shipping and insurance costs. So we work with clients on these matters, but again, it's very difficult to give specific guidelines because it's country specific, and depending on which market you're trying to enter, then we'll just provide different advice. So I think, the last point that I would make, and it will echo what Griffen was saying about the risks that are associated with engaging in these activities, is that we're talking about a crop that looks and smells very much like marijuana. So there's still a lot of confusion, even within states where the crop is lawful. And part of the issue has to do with the fact that as of now, we're still trying to come up with universal, reliable testing protocols that allow custom agents, for instance, to measure the exact level of THC that's found in the crop. Right now, most have access to tools that only measure whether or not THC is present, which of course doesn't help us in that's, we need to know exactly the content of THC in order to be able to make a distinction between marijuana, which is illegal, and hemp, which is lawful so long as it contains no more than 0.3% THC. So those are some of the main considerations for exporting hemp and hemp seeds. Now I'm going to turn over to hemp CBD infused products, which is a whole nother a whole other issue. So as we already explained, hemp was removed from the definition of marijuana under the Controlled Substances Act with the enactment of the 2018 Farm Bill. And of course, the 2018 Farm Bill also provides that the FDA maintains authority over the regulation of hemp CBD products. So this means that the Customs and Border Protection, which inspect any imported and exported products that come to this country, are basically enforcing regulations that are adopted by other federal agencies. And so in the case of hemp CBD products, that would be the FDA. So the CBP consults with the FDA in clearing all these products that fall under FDA authority. So that includes foods, dietary supplements, drugs, cosmetics, and tobacco products. So this means that right now, even though the FDA has not issued clear regulations for these products, we know at a minimum that the FDA takes a strong stand against the sale and marketing of CBD infused foods and dietary supplements. So we know that there are significant risks in importing these products to the US because of the FDA's position. Now, when it comes to cosmetics, it's a lot less clear in that the agency doesn't seem to take issue with the sale and marketing of these products, so long as they're not adulterated or mislabeled, for instance. They're free of health claims on the product packaging and label. And then when it comes to the third category of products that we see the most, which is hemp CBD smokables, well, the FDA has not expressed an opinion at all about these products, but what we do know is that generally speaking, the FDA has refused to extend its authority over smokable products that do not contain tobacco or nicotine. So that's kind of the, a very brief summary of what the agency's position is on these products. So that's kind of what we look at when advising clients on whether or not it is risky to import these products from overseas. But of course, one thing that we do a lot, and Adams will expand on this because that's really his field of expertise and he does this all day long. But when we're dealing with new products, such as hemp CBD products that, the CBP has not emitted an opinion on whether or not they will treat it as, let's say, paraphernalia or or reject, then you can submit a ruling request with the CBP to at least get a better sense of how the agency will treat these products. So that's one way that we can help clients determine whether or not it's a good idea to even bother importing these products. But again, Adams will talk about this a little bit more. But I'm hoping that at some point when the FDA will develop a regulatory path for these products, that other agencies like the U.S. Department of Commerce, specifically their International Trade Association, but also the FSA, which I mentioned earlier, will have more guidelines, and that people like you and me will be able to call them and get clearer information. But for the time being, it's still murky, and why it's so important to work with people like Adams who have experience dealing with customs in determining whether or not it's feasible to import these products. The next point I'm going to touch on is the exportation of these products, which is not much more clear, unfortunately. It's also something where we don't have clear guidelines, and so it's really important, again, very similar to what I described for hemp and hemp seeds, to determine whether the state from which these products are being exported has laws that authorize for the manufacture and sale of these products, if the state has issued any guidelines or imposes any requirement for the exportation of these products. Oregon, again, right, has that very strict law about exporting products that contain no more than 0.3% total THC. If at a minimum, you should, again, have copies of licenses and COAs to show that your products were produced lawfully and meet the definition of hemp under federal law in the US. Now, the big challenge here is to determine, okay, can you export these products to a foreign jurisdiction? Does the country that you're trying to reach allow for the importation on their end of these products? And if so, what are their licensing requirements? Do you need to get a permit of some sort? What are their testing requirements? Again, a lot of these products in Europe range from having to have a THC content that's as low as 0.1% in jurisdictions like the UK. In Italy, they're usually around 0.2. Switzerland has laws that are a little more lenient, in part because they're not EU members, and so all of that has to be taken into account when researching which state or which country you're trying to export to. And of course, these countries have their own manufacturing requirements and other laws that certainly are important when looking at these markets. So with that, I know it was a lot of information, but I'm going to turn to Vince to talk about the import and export of medical marijuana, because we're past the halfway point, but I'm happy to answer any questions that will come up.
I'm going to raise one or two quick questions before we move on that have been asked. I think Griffen can answer this one. The question is, what are your thoughts on the utilization of foreign COAs versus US-based lab COAs? Could USDA guidelines for domestic analysis impact requirements for imported hemp and derivatives?
So foreign COAs have help. They can be beneficial. Like, we've reviewed tons of COAs from European countries. I speak German. I've looked at a lot of COAs in German and other languages, and generally they can be helpful to establish that you've done some testing and that your product is hemp, but it's not really going to be dispositive in the United States. In most states that I'm aware of, they require you to do testing through some kind of US. Recently, there was going to be a DEA certified lab. So it's not going to, if you're making a hemp product out of plant material, for example, that was derived in South America or Europe, you're going to need to do testing again, and that COA is not going to be, it's just going to be meaningless with respect to that future testing. But when you're bringing plant material or hemp CBD product into the United States, it's another thing you can use to show compliance with the foreign state's law and to prove that the product you're bringing in is not illegal marijuana.
Okay, thanks. I'm sorry, guys. I was muted for a little bit, and I apologize. When I read that question, I should have explained that COA refers to, I think, certificate of analysis. Is that right, Griffin? I think maybe everybody understands that, but I should read it better. Another question before I move on to this medical marijuana export topic is, somebody asked, is there anything in USMCA related to the CBD trade? USMCA is the US-Mexico free trade agreement. It kind of sometimes referred to as NAFTA 2.0. I looked at it when it first came out, and I don't think there is any mention of CBD, let alone even hemp or cannabis of any type. But the sort of good news for that is these free trade agreements or trade agreements generally are open concepts to the extent that they last for many, many years. There's the ability for the parties to establish what we call working groups within them. I think in USMCA, it's called the Free Trade Commission. And it's certainly possible that somebody could bring this concept to that working group and then incorporate it into USMCA. So especially with Mexico now coming online for marijuana legalization nationwide, and Canada being a huge export country and US laws slowly starting to change, I wouldn't be surprised if at some point in the near future USMCA incorporated the CBD trade or some form of cannabis trade, but right now nothing. So those are the questions I think we'll cover there for now. I'm going to move on just in the interest of time because I would like to briefly cover export of medical marijuana. And I'm going to plug this by saying I'm only going to talk about this for 5-10 minutes now, but if you're really interested in this topic, which is it's a growing market, it's a fast growing market, I'm going to be presenting at the International Pharmaceutical Association's Medical Cannabis Conference. That's in Toronto, May 6th through 8th, and it's actually 3 days just on this topic, and it's going to have a lot of pretty qualified government and private sector people, and it's going to provide people with insight on a plethora of information with respect to import and export and research and science of medical cannabis. But I think for now, for today, suffice it to say that export of medical cannabis is happening right now. It's happening all over the world. It's being exported primarily by a couple of countries. Canada is far and away the leader in medical cannabis export. The first countries to actually pass domestic legislation to allow export were Canada and the Netherlands. A few others have recently joined their ranks. Israel notably joined, I think, in December. Israel's always been a big center of cannabis research, but now it's announced that it's going to become the cannabis exporter in the medical marijuana context. Other countries like Uruguay, Australia, Denmark, lots of EU countries actually allow the import of medical marijuana and have laws in and around that. And even countries like the US, which is a pretty prohibitionist country in the grand scheme of things, has allowed limited import of medical marijuana. That happened a couple of years ago for a specific study, I think related to a seizure drug. I can't recall, but it's happening. Medical marijuana is being exported, like I say, all over the world. So how do you do it? Well, first, you obviously have to start in a country with federal laws that allow for medical cannabis production, right? So if you're looking at North America as an example, that means you've got to be in Canada or perhaps in Mexico, which is now coming online for broad cannabis legalization. You cannot be a medical marijuana exporter from the United States, right? US federal law doesn't even recognize any sort of concept around medical marijuana. It's all just prohibited cannabis except for hemp. Second, in addition to having the location where you've got an appropriate sort of federal statutory structure, you've got to start in a country with a progressive national health department and an exporting authority. So this means that, say you're in Israel right now, right? Israel announced it's going to start exporting medical marijuana. Well, have they developed an exporting authority yet? Do they have a national health department that's written regulations that can sort of move this plan forward? It's not enough just to say we're doing this. You've got to sort of look at, are the laws in place, are the protocols and permits and regs in place? Is all of that built out enough such that I can export in the way that Canadians now can? Third, you've obviously got to target a country that allows for medical cannabis imports. A lot of them don't. A lot of them do. More and more will by the end of this year and in the coming years. The next thing you've got to do is find a trading partner, obviously. If you're an exporter, your trading partner could be a private company or it could be a government, depending on the structure of the target company's, or excuse me, the target country's domestic laws. So some governments themselves will be the importer. In other cases, private companies will be allowed to import, say for a scientific study, like I mentioned. Then you've got to enter into an agreement. Obviously, those agreements are kind of complex. They're contingent on a lot of things. One is obviously the acquisition of import and export permits and other factors. So they may look more like an LOI or an MOU to start, or they could just be a contract with all kinds of contingencies. Strike a deal. And if you actually get that far and you've begun to export cannabis, that's got to all be reported, right? Now that gets reported by and through the country itself. The country has issued you a permit to export cannabis. It tracks the amount that you're exporting. Usually that's done in imperial tonnage, I believe. And those are under standards by the International Narcotics Control Board that I mentioned. They are tasked with tracking the volume of import and export of controlled substances. They've been really clear that there are no upper limits or quotas on the quantity of narcotic drugs, quote unquote, including cannabis, that are produced globally for medical and scientific purposes. So there's no limit, essentially, as long as you've got the correct permits in place and you're doing the reporting that your country's doing the reporting that it's required to do to the INCB. The way that all works is every June, countries have to submit to INCB their sort of estimates for cannabis import and export for the year, and the INCB looks at that, and they compare the reports from those countries to the reports for the intake countries. And if numbers are out of line, they ask people to take corrective measures or ask them why they missed their estimates, things like that. And then the INCB will publish a big report each December, which includes the total imperial tonnage that has been shipped in the prior year. As I mentioned, Canada is far and away the export king right now. You can kind of paw through the report and find respective tonnage per country. General market research indicates that Canada did something like 15 billion in international sales of medical cannabis last year. So other countries will probably catch up, but that's kind of the lay of the land right now. That's really high level stuff. I don't think I'm going to get any more into it than that. Instead, I think I'm going to turn over to Adams next, and Adams is going to talk to us about customs issues.
Thanks, Vince. So I'm part of our international trade group, and we do a lot of work with U.S. Customs and Border Protection. So I'd like to talk a little bit about, what does CBP actually do, and how do importers have to prepare to deal with CBP and in their interactions, either importing goods or exporting goods. So CBP, they are essentially the gatekeepers who are to review any and all importations or exportations of goods in or out of the United States. So you can imagine the volume of products that are going in and out of the country. In the good old days, when the country was first formed, Customs was very proactive in basically reviewing, all transactions going in and out. But now, given the volume that we're talking about, we are essentially operating on an honor system. So importers have an affirmative obligation to exercise what's called reasonable care in terms of declaring their goods to U.S. Customs when they're importing or exporting goods to the United States. So, what is reasonable care? It is a pretty vague standard, but a lot of it is, referring to outside experts, seeking guidance from customs and or other agencies that are relevant to the product at issue. And so for new products, such as the marijuana, hemp, CBD oil spectrum, where you're not getting that guidance, then it gets a little bit challenging to figure out, are you exercising reasonable care in terms of bringing in these products? When an agency is unwilling or unable to give such guidance, then it's still upon the importer to exercise quote unquote reasonable care when they bring in the products. So We know many importers are bringing in products. The question is, are they exercising reasonable care in doing so? And given the lack of guidance that's out there, there is definitely a degree of risk that's inherent in bringing in these types of products. So one way of trying to show that you are exercising reasonable care is to apply for a customs ruling letter. This can pertain to the classification of a good, the valuation of a good, the country of origin of a good. So these are all issues that customs can make a determination on to help you identify, what is the proper way to declare these goods when you're importing these goods. In general, we're focusing primarily on importation because customs tends to focus on importations because there are duty collection issues with importations. And so, customs tends to focus most of their efforts on the importation side of things. Customs does also track exports as well, and there are occasionally we do see issues with exporters running into issues when they export and they don't comply with statistical reporting requirements for customs, but primarily most of our work is on the importation side. On the exportation side, we don't deal so much with US customs, but we're usually dealing with the target export country. We're dealing with the customs agencies in those countries to try to figure out, what are their import requirements to let the US products into their countries. So with regard to CBD products, we've seen recently over the past few years a good number of ruling requests that have gone into customs asking for guidance on a wide variety of CBD products. So we've seen ruling letters issued by customs on products like bulk CBD oil, hemp biomass, aromatherapy CBD oil, CBD in bulk powder form, hemp protein powder, hemp seed oils for dietary supplements. So customs has made rulings on these types of products, and generally because of their new products, the importers are not sure, how should we classify these. The U.S. uses what's called a harmonized tariff schedule that's supposed to be able to classify any and all products that come in. Now, this is basically a classification system that was set up, many, many years ago. And so when new products are developed, customs along with the importers are trying to figure out what HTS number am I going to use to classify this new product. And so the importer often will go into customs and say, look, we've looked through the possible HTS categories that we think might work for this product. And we think that this category is probably the best one. And they'll present the factual argument regarding, the product and the description, and to see whether it fits the category description for that particular HTS number. And then customs may come back and say, great, we agree with you, or they may disagree with you and they'll present their arguments as to why they think another HTS number is the appropriate one. So, choosing the HTS category can have a direct dollar impact because there are different duty values assigned to different categories. So, you may, as an importer, see an HTS category as a lower duty rate, and you can say, hey, can we try to get it classified under that HTS number? And sometimes it's a stretch. Sometimes you have pretty good arguments. So that's something we work with importers to try to figure out. Are there more favorable HTS classifications that we can try to bring these products in? and so, we do a lot of work on classification rulings. Lately, we're doing a lot of work on country of origin rulings, especially with China tariffs. So, with the tariffs on China, a lot of people are trying to get their products, made somewhere else, even if they start off in China. So, trying to figure out, how much processing has to be done in a third country before it stops being a product of China and becomes a new product in that third country. So I see we've gotten a lot of questions on, how can we import, other products like vaping pens, CBD infused alcohol products. Those are all potential products that could be subject to a customs ruling request. You could say, hey, look, we think these products should be classified under HCS number X, and see if customs agrees with it. There's a lot of ancillary products to this industry, whether it's grow systems, vaping hardware, cartridges, pens, that are all potentially subject to customs classifications. And customs, they often will defer to other agencies. So, for instance, on these CBD products, those ruling requests, they specifically mention, that they're just ruling on the customs classification on these products, but that these products would still be subject to FDA or other agencies, including DEA. So that brings me to the other topic that we cover in the customs realm is seizures. So because customs can and has seized products, believing that it's marijuana, the area that we see a lot of matters in is when customs seizes an entry of goods and deems it to be drug paraphernalia. And so drug paraphernalia is deemed to be, under US law, as any equipment, product, or material of any kind which is primarily intended or designed for use in manufacturing, compounding, converting, concealing, producing, processing, or preparing, or otherwise introducing into the human body. So the issue of primarily intended for use has become the key legal factor for trying to figure out, things with customs. And, we work with a lot of importers who made the argument and say, look, we've imported this product thousands of times before, and, why is customs seizing it now? Can they do that? And yes, because it has, because customs operates essentially on an honor system, they're not able to check every single entry. But if and when they do decide to make a check on an entry, they are well within their legal rights to determine that, hey, this particular entry was drug paraphernalia. So, but is it still possible to challenge customs seizure determinations? And yes, there definitely are ways. Customs itself has internal ways that you can go administratively to either first report customs headquarters, or you can even go to the Department of Justice to challenge a seizure. So we've worked with some importers who have had entries that have included, certain smoking bowls, pipes that clearly are drug paraphernalia under customs definitions, but they've also had bags, retail bags, paper bags that have also been seized. And we've been able to successfully argue that some of the ancillary products that are not related to the, producing or ingesting of drugs should not have been seized, and we've been able to get those released from customs because those were not drug paraphernalia. So many issues that are related to just the customs clearance of products in this area. And happy to take any questions that you might have.
Okay, let's move on to the last section in the last 5 or fewer minutes on foreign direct investment in cannabis businesses. Griffen, I'll let you lead this one and I'll chime in at the very end.
Sure. So I'll try to crunch this into a few minutes because there's really a lot of issues, and this one topic could be its own webinar in and of itself. I did see a question earlier that asked about jurisdictions in the United States that allow foreign direct investment via offshore companies, and some states may allow like what we've thought of as an offshore investment, but the vast majority of states, I'm not aware of any state that would allow investments with no knowledge of the beneficial owners or where that investment's coming from. So if the intent is to try to get around disclosing owners to a state, that's probably not going to happen. The big distinctions between marijuana and hemp when it comes to foreign direct investment are that the fact that hemp is potentially legal where marijuana is not legal under federal law. So many of the same issues won't apply. I'll also note that marijuana is legal in most countries in the world. So there will probably be issues as well in the home country. If hemp is illegal in the home country as well, then there can be additional issues with respect to hemp. One of the biggest issues, though, is an immigration issue, which most businesses won't think of right off the bat. There are two agencies here, CBP and U.S. Citizenship and Immigration Services, that are regulating this. CBP issued a statement about 2 years ago saying participants in the Canadian state licensed cannabis industry cannot enter the U.S. if they're involved in criminal activity, which necessarily means the state legal cannabis activity. And a few Canadian citizens were even banned for life from entering the United States. I think that was subsequently reversed, or there's a lawsuit ongoing about that. But anyway, it shows just how impactful this can be. And I've been asked by many people before, what if we just say we're just coming to the United States for a vacation? And that could be considered fraud on the CBP and could also lead to a lifetime ban or other issues. So that's very highly not recommended. The other agency, Citizenship and Immigration Services, changed its policy last year with respect to naturalization. One of the things you need to establish to become a naturalized citizen here is good moral character. And they've issued guidance that said basically, if you're involved in the cannabis industry, or in some cases even possessing cannabis or using it, you may not be able to establish good moral character. So you can be both barred from entering the United States and potentially barred from staying in or even deported from the United States based on investment into a cannabis business if you're in the country for that reason. Also, background checks that are done at the state level are done in the federal database. And some states will require this for hemp as well. So you may be flagged to the federal government if you're affiliated with a company that's doing this. State laws generally will require some kind of personal information to be disclosed for owners of a cannabis company, or in some cases investors. And this usually is a social security number, or if they don't have one, an individual taxpayer identification number, also called an ITIN. And so this poses other issues for foreign investors who don't have those numbers, and getting an ITIN can take several months sometimes. So we've done a lot of deals where one company on the other side of a deal, for whatever reason, is considered an owner or financial interest holder of a cannabis company. And because the agencies go all the way up to the company at the top, if that company at the top is, let's say, Canadian, you may need to have the board members and officers at that company go through disclosures. And if this process wasn't thought of before an investment is made, it can actually violate the rules because there's only very tight windows to provide these disclosures, which required the SSN and ITIN at the time of disclosure. So it can be a very complicated process and take many months. And that's the thing that I think makes foreign direct investment the thorniest, besides just the immigration issues. Also, some states, Washington is the big one, have a residency requirement, meaning you can't own a business unless you actually reside in Washington. So in states like that, foreign direct investment may not even be possible. And the last thing I'll point out with respect to foreign direct investment is that if your foreign direct investment somehow renders your company a participant in the U.S. cannabis industry, it's very likely that U.S. privacy laws will apply to it, for example, the CCPA. And if goods are sold or exported to Europe or from Europe, the GDPR may apply as well, which will make all kinds of other compliance obligations there, which weren't there before.
Okay, thanks everybody. We're out of time, so I'm not going to add anything, but we appreciate you joining. Stay tuned to the CannaLaw blog, CANNALAW blog.com, because we will post questions that you've asked that we couldn't answer, and we will repost the webinar. And thanks again for joining.